The Supreme Court hands down judgment today in the case of the Queen on the application of SC and others, and the Secretary of State for Work and Pension and others. I should explain at the outset that the Court has made an order in this case that no one is to publish or reveal the names or addresses of the appellants, or indeed any information which would be likely to lead to their identification. Child tax credit is a benefit intended to provide financial support to families with children. It consists of three elements: a family element, an individual element, and in respect of disabled children, a disability element. As a result of legislation enacted in 2016, the individual element is limited to the amount payable in respect of 2 children. No additional amount is payable in respect of a third or indeed subsequent children born on or after the 6th of April 2017, unless one of a number of exceptions applied. The fixing of the limit on the basis of the sum payable for 2 children reflects the fact that the average UK family contains 1.7 dependent children. The appellants are 2 women, known in these proceedings as SC and CB, together with SC's 3 youngest children and CB's 5 children. They've brought proceedings against the Secretary of State for Work and Pensions and other ministers, claiming that the 2-child limit is incompatible with rights protected by the Human Rights Act. Their claim was dismissed by the High Court, and their appeal was dismissed by the Court of Appeal. They now appeal to the Supreme Court. The Supreme Court unanimously dismisses the appeal. The Court rejects the appellant's argument that the 2-child limit was intended to discourage women in receipt of child benefit from having more than 2 children, and therefore violates their right to respect for their private and family life, as guaranteed by Article 8 of the European Convention on Human Rights. The Court also rejects the argument that the 2-child limit has a damaging effect on the integration of third and subsequent children into their families, and therefore violates their Article 8 rights. The evidence does not support those arguments. The Court also rejects the argument that the 2-child limit violates Article 12 of the Convention, which protects the right to marry and to found a family within marriage. That article doesn't apply in the present case. The adult appellants do not intend to marry the fathers of their youngest children or to found a family with them. Even if they had such an intention, Article 12 would not impose an obligation on the state to provide the material means which would enable them to found a family. The appellant's primary argument is that the 2-child limit breaches their right under Article 14 of the Convention not to be discriminated against in the enjoyment of Convention rights. In order for an issue to arise under Article 14, the appellants need to establish that their complaint falls within the ambit of one or more of the rights guaranteed by the Convention, and that it concerns a difference in treatment based on a relevant characteristic or status between persons in analogous or relevantly similar situations. The Court decides that the adult appellants can satisfy each of those requirements. Their complaint falls within the ambit of both Article 8 of the Convention, since it relates to a benefit designed to contribute to family life, and also Article 1 of the First Protocol to the Convention, which protects interests in property, including entitlement to state benefits. The parties agree that although the relevant provisions of the benefits legislation are couched in neutral language, in practice, the 2-child limit affects more women than men. That's because the majority of single parents are women. This gives rise to a presumption of discrimination on the ground of sex, and therefore requires to be justified. The Court accepts that the child appellants have also set out a relevant complaint, falling within the ambit of Article 8 of the Convention, so far as they complain that children living in households with more than 2 children are treated less favourably than children living in households with 2 children or fewer. The remaining question then is whether the relevant differences in treatment, first between men and women, and secondly between children in families with 2 or fewer dependent children and children in larger families, are justifiable. In relation to that question, the court considers 3 issues of general importance which arise from the parties' submission. First, the court decides that it is not appropriate for domestic courts to determine whether the United Kingdom has violated its obligations under unincorporated treaties, such as the United Nations Convention on the Rights of the Child. Secondly, the court clarifies that a low intensity of review is generally appropriate, other things being equal, in cases concerned with judgments of social and economic policy in the field of welfare benefits and pension. In other words, the courts will generally accept the judgment of the legislature or the executive as to whether a difference in treatment is appropriate in that field, unless it's manifestly unreasonable. This is not, however, a mechanical rule. The intensity of the court's scrutiny can be influenced by a wide range of factors depending on the circumstances of the case. In particular, very weighty reasons will usually be needed to justify a difference in treatment based on so-called suspect grounds, such as sex, gender, or race. Thirdly, the court considers the use which can be made of parliamentary materials when considering whether primary legislation is compatible with convention rights. The court makes clear that the will of Parliament finds expression solely in the legislation which it enacts. Ministerial statements cannot be attributed to Parliament or treated as indicative of Parliament's intention. Material placed before Parliament and statements made in the course of debates may, however, be relevant as background information in ascertaining the objective of the legislation and its likely practical impact. Material of that kind may also be relevant in demonstrating as a matter of fact that issues bearing on proportionality were considered by Parliament during the course of legislative proceedings. Nevertheless, the proportionality of a statutory measure is not to be judged by the quality of the reasons advanced in support of it in the course of parliamentary debate, or by the subjective state of mind of individual ministers or other members of the legislature. Applying those principles to the facts of this case, the court concludes that the 2-child limit has an objective and reasonable justification, notwithstanding its greater impact on women. The measure pursues a legitimate aim: to protect the economic well-being of a country by achieving savings in public expenditure and thus contributing to reducing the fiscal deficit. It was inevitable that if that aim was to be achieved, there would be a disproportionate impact on women, since women are disproportionately represented among parents responsible for bringing up children. Parliament decided that the disproportionate impact of the 2-child limit on women was outweighed by the importance of achieving its aims. There is no basis on which the court could properly take a different view. Finally, the court concludes that the difference in treatment between children living in households with more than 2 children and children living in households with that number of children or fewer is also justifiable. Parliament's objective of ensuring that the child tax credit scheme is fair and reasonable by limiting the extent to which recipients of the benefit are guaranteed a rise in income if they have additional children is legitimate and could only be realized if a limitation on entitlement based on the number of children living in a household were introduced. Parliament took account of the impact of the limitation on the interests of the children affected and decided that that impact was outweighed by the reasons for introducing the measure. The assessment of proportionality, therefore, ultimately resolves itself into a question as to whether Parliament made the right choice. That is a question of intense political controversy, which cannot be answered by any process of purely legal reasoning. There is no basis consistent with the separation of powers under our Constitution on which the court could overturn Parliament's judgment that the 2-child limit was an appropriate means of achieving aims.